Hello everybody. Welcome to iExamB's Legal Bee. This is Amrita, your law faculty here at iExamB. Embrace the iExamB learning experience with us. In this video today, I'm going to discuss with you all a very important content for RBI Grade B Legal Officer examination. But before we start with our discussion, don't forget to subscribe to our YouTube channel Legal Bee. If you're preparing for any competitive examinations after your law, then you can check out all the online courses available on iExamB's website. आप इन कोर्सेज के डेमो चेक कर सकते हैं. कोई भी क्वेरीज हो, रीच आउट टू अस बाय राइटिंग अस एन ईमेल ऑन hello@iexamb.com और यू कैन कॉल अस ऑन दिस नंबर. वीडियो के कमेंट सेक्शन में भी आप हमें रीच आउट कर सकते हैं. डाउनलोड आवर ऐप फॉर 50% फास्टर जॉब प्रेपरेशन एंड ऑल्सो डोंट फॉरगेट टू सब्सक्राइब टू आवर यूट्यूब चैनल लीगल बी. On Legal Bee, we keep on bringing various videos that are important for your exam preparation and also the current affairs, the content that is very much relevant for lawyers and all the people who are giving any competitive examinations after your law, and also strategic preparation video for these examinations. आज के वीडियो में हम लोग RBI ग्रेड बी लीगल ऑफिसर एग्जाम के प्रीवियस ईयर पेपर के क्वेश्चंस डिस्कस करने वाले हैं. दिस प्रीवियस ईयर पेपर इज ऑफ द ईयर 2021. दिस डिस्कशन विल बी वेरी हेल्पफुल फॉर यू टू हैव वेरियस इंसाइट्स अबाउट दिस एग्जाम. प्रीवियस ईयर पेपर देखने के बाद हमें कई सारी चीज़ें समझ में आती हैं कि किस तरीके के क्वेश्चंस होते हैं, कितने क्वेश्चंस होते हैं, हाउ, एंड इफ़ यू आर एबल टू अटेम्प्ट दीज क्वेश्चंस इन द फॉर्म ऑफ अ टेस्ट, इट इज़ ऑल्सो गुड. यू कैन चेक आउट ऑल द मॉक टेस्ट्स and the previous year papers available on iExamB's website as well. This will definitely help you out in your preparation. आपको ये एग्ज़ाम रेडी बनाता है एंड आपको ये बताता है कि आपको किस डायरेक्शन में प्रिपेयर करना है, कौन से एरिया, कौन से टॉपिक से क्वेश्चंस पूछे जाते हैं. So do check out this video till the end. I have also discussed the solutions with all the questions. Question number 1. Any matter expressed or described upon any substance by means of letters, figures or marks, or by more than one of these means intended to be used or which may be used for the purpose of recording that matter is. Very simple and direct question. This is definition of document has been taken up from section 3 of the Indian Evidence Act. So the correct answer is document. Question number 2. A tribunal shall not dash unless it is satisfied that the applicant has availed all the remedies available to him under the relevant service rules or to redressal of grievances. This is correct answer is ordinary admit and application. This statement has been picked up as it is, which is section 20 clause 1 of the Administrative Tribunals Act 1985, which says a tribunal shall not ordinarily admit an application. What is the criteria for admitting an application? It should be satisfied that the applicant has availed all the remedies available under the relevant service rules as to redressal of grievances. This is relating to Administrative Tribunals Act 1985. Third question. All proceedings before a tribunal shall be deemed to be judicial proceeding, non-judicial proceeding, show cause hearing, all of the above. Correct answer is judicial proceeding. Section 30 of the Administrative Tribunals Act 1985 talks about it. Proceedings before a tribunal to be judicial proceedings. Where an agent holding an express or implied authority to name another person to act for the principal in the business of the agency has named another person accordingly, dash. This is relating to agent. This is picked from Indian Contract Act, section 194. Talking about the relationship between principal and person duly appointed by an agent to act in business of agency. And the statement is as it is, where an agent holding an express or implied authority to name another person to act for the principal in the business of the agency has named another person accordingly, such person is not a sub-agent, but an agent of the principal for such part of the business of the agency as is entrusted to him. So the correct option is A. Accordingly, such person is not a sub-agent but an agent of the principal for such part of the business of the agency as is entrusted to him. So he is an agent of the principal. This is very clear in section 194 itself. Question number 5. If due to some unavoidable accident, a document executed in India is not presented for registration till after the expiration of the prescribed time, but the delay in presentation does not exceed 4 months, can the document be registered? Yes, on the payment of fine not exceeding 5 times the amount of proper registration fee can be registered at the discretion of the registrar depending on the circumstances. It cannot be registered. Yes, on the payment of a fine not exceeding 10 times the amount of the proper registration fee. This is from Registration Act, Section 25, Clause 1 deals with it. If owing to urgent necessity or unavoidable accident, as it is, this has been picked up from here, from this section, and the criteria for it will be payment of fine not exceeding 10 times the amount of the proper registration fee. Question number 6. A civil suit shall be instituted in which court? Section 15 of CPC talks about it, courts in which suit is to be instituted, and the criteria is that the lowest grade that is competent to try it. The court of the lowest grade means the jurisdiction will lie with the court which is having the competency to try that matter lowest in the hierarchy. If you can put that matter even before the district court or a high court, but if it is triable by the civil judge senior division first, definitely civil judge senior division will be the first court to try it, and the court shall and the civil suit shall lie first in that court only that is competent to try it in the lowest grade. Section 15 of CPC provides that. Question number 7. No objection as to the place of suing shall be allowed by any dash unless such objection was taken in the court of first instance at the earliest possible opportunity, and in all cases where issues are settled at or before such settlement, and unless there has been a consequent failure of justice. Again, another question from CPC relating to jurisdiction only. Section 21 of the CPC talks about objections to jurisdiction. So that provides for this, and the correct answer is appellate or revisional court. No objection as to the place of suing shall be allowed by any appellate or revisional court unless such objection was taken in the court of first instance at the earliest possible opportunity. Because this jurisdiction related question, objection should be raised in the first instance only, before the first court only. If it is not raised, then appellate or revisional court are not bound to do that. 8th question. Facts shall be proved by dash in every plaint. Affidavit is the correct answer. Easy question. Section 26 clause 2 talks about institution of suits in CPC, and it makes a mandate that every plaint shall have facts that are proved by or supported by an affidavit. When can a promissory note payable by installments must be presented for payment? Section 67 of the Negotiable Instruments Act talks about it. 3rd day after the date fixed for payment of each installment. So this is a direct question relating to promissory notes. When they are payable by installments, they must be presented for payment on the 3rd day after the date fixed for payment of each installment. Picked from Section 67 of the NI Act. 3rd day is the correct answer. The transfer of an interest in specific immovable property for the purpose of securing the performance of an engagement which may give rise to a pecuniary liability is known as. Section 58 of TP Act talks about mortgage definition, and this is what is a transaction of a mortgage only. Specific immovable property interest is transferred, and what is the purpose? Focus on the purpose always. You will very easily be able to classify whether it is sale, mortgage, gift, what it is. So this is mortgage, because securing the performance of an engagement which is giving rise to pecuniary liability, then definitely it is giving security for that amount of money that is given in the form of loan, or it is going to be an engagement for pecuniary liability. When one fact is declared by Indian Evidence Act to be conclusive proof of another, the court shall, on proof of one fact, regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. When you get this last line only, you can make it out that this is talking about conclusive proof. Section 4 of the Evidence Act talks about conclusive proof. When one fact is declared by the Act to be a conclusive proof, then court will not allow any evidence for proving or disproving it. The provisions relating to dash are given under Article 24 of the Constitution of India. From Constitution, we can definitely expect direct questions like this, sometimes article based as well. So we should always be prepared with the landmark questions, landmark sections or articles from the laws if we get direct questions like this. Article 24 talks about no child below the age of 14 years shall be employed to work in any factory or mine, engaged in any other hazardous employment. So it prohibits child labor completely. So prohibition of employment of children in factories, etc. is the correct answer over here. Which article of Constitution of India provides that all laws in force in the territory of India immediately before commencement of the Constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void? They have directly picked the article. By reading the article, the question itself, we can make it out that it is Article 13. Article 13 clause 1 has been directly picked over here. Again, a very easy question. Article 13 is very important article of the Constitution. As per Section 24 of the Registration Act 1908, where there are several persons executing a document at different times, such document may be presented for registration and re-registration from dash, within dash from the date of each execution. So the time period has been asked over here, that when documents are executed by several persons at different times, then what will be the time period from the registration and re-registration? That is going to be, the correct answer is 4 months, and that has been picked. The section number they have mentioned already in the question only. Section 24 you can mark as an important section from Registration Act. Registration Act is completely an act from where you can get simple questions like this for procedure, like documents, what are required, time period, and all these kind of questions. According to which rule of interpretation, the words of a statute are to be first understood in their natural, ordinary, or popular sense, and phrases and sentences are construed according to their grammatical meaning, unless that leads to some absurdity, or unless there is something in the context or in the object of the statute to suggest the contrary. This rule talks about grammatical rule because it says that you give the normal or the ordinary meaning to the sentences and the phrases. Unless there is some kind of contrary suggestion, you should always stick to grammatical or literal rule. It is also known as the plain meaning rule for this reason. So these were the MCQ questions from the previous year paper. That is done. Now let us move towards the descriptive questions. There are 4 descriptive questions. We will also see the descriptive questions in this video and get an idea that what kind of questions are asked. Question number 1. Bharat borrowed rupees 12 lakhs from bank as a security container valuing rupees 25 lakhs of glacial acetic acid that were deposited with the bank. However, later on, Bharat had financial difficulties and the bank took further security in the form of personal guarantee from Amar and Samar in order to secure repayment of loan. This was a guarantee. Both Amar and Samar gave the personal guarantee. However, at the time, Amar was not aware of the security. Samar was aware about the available security. On failure of payment of loan to bank issued notice to Bharat, Amar as well as Samar. Amar offered to pay back the complete loan amount if he can have entire security being handed over to him. However, the bank officials had doubt whether they can give security to Amar since he was unaware of security at the time of the guarantee. For purpose of recovery, bank gets approved valuer to check the market worth of raw material. Approved valuer took help of chemist and on opening of random container found water instead of acid. Opening other containers also resulted in the same. There is this last line you can just skip. For purpose of recovery, bank gets approved valuer to check the market worth of raw material. So this is what is the question up till here only. The last line is an error. On this, you have to analyze the situation and you have to write descriptive answers. On this, you have to write 3 descriptive answers. First one is analyze the situation and clarify doubts of the bank officials. Second one is what are the liabilities of Amar and Samar. And third one is what are the legal obligations of Bharat and bank. So this is very simple question if you are aware of the relevant provisions relating to guarantee, surety related and their liabilities. So this is picked from where I will tell you so that you can practice your answers looking at this question. Definitely you can write your answers of these descriptive questions. अगर कोई भी queries हो आप हमें इस वीडियो के comment section में directly reach out कर सकते हैं. We will clarify all your doubts and also we can help you with the MCQ questions also if you have any queries. This last line, as I told you, I apologize, it was not an error. It is relating to a twist in the question that approved valuer took help of chemist and on opening of random container found water instead of acid. So there was water. So the material that was there, that was also not acid. So opening the other containers, they all completely all the containers were only having water and not acid. So this also is very important in determining the liability and the legal obligations. Now I would like all of you to pause the video and read the question again. Take some time. You can also download the PPT of this video. These questions will definitely help you. You can practice them out. Koi bhi queries ho, we are there to help you. Reach out to us. Indian Contract Act Section 140, rights of surety on payment or performance is involved in this. Section 146, co-surety is liable to contribute equally. That is also there. Amar, Samar, I think you are understanding. Koi bhi queries ho in relating the questions with section, you can also reach out. Section 141, surety's right to benefit of creditors' securities, and Section 145, implied promise to indemnify surety. Next question. Chandra Brothers entered into an agreement with Messrs. Quick Toy Private Limited, the company, for supply of raw material and paid rupees 2 lakh in advance. Messrs. Quick, unable to fulfill the order, gives 2 checks on April 20th dated 2nd May and 3rd August. Checks were signed by Mr. Rohit, financial manager of the company. On April 30, Mr. Kaushal, financing director, approaches Chandra Brothers and requests them to present both checks on 3rd August as they are right now short of fund. On 3rd August, Mr. Chandra presented the checks to the bank but both got dishonored, and on 12th August he got receipt memo stating on to be stating check and other to be exceeding arrangements. Mr. Chandra then investigated and found that the company was a sick company. Further, when he approached the company, he found that avoiding the meeting. Mr. Sood, the managing director, and Mrs. Prema Sood, the executing director, were the only directors on board of members. Other than them, Mr. Kaushal was also on board. Mr. Chandra approaches you for consultation and remedy. As advice, you tell him it would have been a criminal case, but he has missed the chance. So this is again a legal problem for which you have to give a solution. Your solution should be backed by legal sanctions. Remember that. What are the questions on this? What chance did Mr. Chandra miss? Who is liable for check dishonor in case of company? What is the procedure to file a criminal complaint? This is a simple question. 10 marks each. 3 questions. Negotiable Instruments Act relevant provisions that are attracted here are 138, 141 and 142 relating to offences of companies and cognizance of offences as well. Third question, read the passage given below and find the doctrines applicable to them. Explain with the application as well. Z Machines, a New Delhi based company, entered into a contract with Prompt Sales Limited, New Delhi, for 2 printing machines to be supplied to the latter for its Delhi office and Pune office. 2 machines were found to be defective. Hence, Prompt Sales filed a suit for breach of contract through its representative in New Delhi court for both the machines. Within a week, branch office Pune also filed a suit in Pune court on the same ground. Amit filed a writ petition in the High Court challenging his removal from the service of central government without holding an inquiry. High Court dismissed the petition on the ground that this removal is as per Article 311 Clause C of the Constitution. Aggrieved by the decision of the High Court, Amit filed a writ in the Supreme Court. Now these are two questions that they have provided here based on doctrine. One is A and one is B. Situation has been given to you. You have to guess which doctrine it is and discuss about the applicability of that. So the solution, I will give you the name of the doctrines. In clause A, doctrine of res sub judice from CPC, and clause B, doctrine of pleasure from Constitution of India. Both of them you have to elaborate and you have to write about it. You have to write about these two in a descriptive manner. 15 mark each question it is. 2 questions have been given. Last question from this paper. What are the documents, the registration of which is optional? Explain the consequences of non-registration of documents that are required to be registered. Second question, explain Article 323A of the Constitution of India that provides for the establishment of administrative tribunals by law made by the Parliament for the adjudication of disputes and complaints related to the recruitment and conditions of service of government servants. Third one, what are the provisions relating to the formation of new states, alteration of boundaries, areas and names of the existing Constitution of India? What is the solution? First one is relating to Registration Act 1908, Section 18 and Section 49 talk about it. Documents of which registration is optional and effect of non-registration of documents required to be registered. Second one is relating to Constitution of India, Article 323A. You have to explain in that. And third one is Article 3 of the Constitution of India relating to formation of new states, alteration, boundaries and names of existing states, the powers of the Parliament with respect to that you have to elaborate. So this you have to write 5 mark each of these 3 questions. You have to elaborate according to the marking. Remember, you have to elaborate all your answers according to the marking scheme. Some questions are having 15 marks, some are having 5 marks. So according to that only you have to write your answers, the points that you have to cover. So this was all from the previous year paper of RBI Grade B Legal Officer Exam 2021. I would suggest you download this PPT and keep these questions for you for practice. कोई भी queries हो, we are there to help you out. Prepare 50% faster with us at iExamB. Download our iExamB app from the Google Play Store and check out all the courses that are available with full course access on our iExamB app as well. Thank you everybody. Have a great day.